Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. We're now looking at the 25 top cases affecting municipal court practice in the past year. Let's start off with DWI. 1. Are there speedy trial rights when it deals with DWI? Yes. State versus Tsetsekas. A DWI was dismissed under speedy trial grounds where there was more than a 360-day lapse. 20-minute observation. Is that applicable? Yes. State versus Ugrovics, but the appellate division ruled the arresting officer can testify as part of the 20 minutes, even though the Supreme Court stated it's supposed to be the Alcotest operator. The state must prove the 20-minute observation of the driver prior to the breath test by clear and convincing evidence. 3. Can the courts sequester all the witnesses, including the defense expert? No. State versus Popovich, there should be no sequestration of the defense expert in a DWI case. 4. Is destruction of a videotape possible defense and grounds to vacate a plea? Sometimes State versus Mastero. However, the defendant there wanted to vacate a guilty plea. The court held that, destruction of the videotape may permit them to vacate the guilty plea, but the burden of proof is upon the defendant, and the court concluded that the defendant failed to establish that he would not have admitted driving and drinking if he had access to the DWI. The court concluded the denial of his motion to vacate his plea was consistent with State versus Slater. 5. Is it a defense to refusal if the breath test warnings are not given in another language? Sometimes, State versus Marquez, the breath test warnings must be given in Spanish to a Spanish-speaking person. 6. Let's say the person is not able to provide 1.5 liters of air. Can the officer automatically write a refusal? No. State versus Schmidt. If not enough breath is supplied, the officer must read the additional warnings prior to the refusal. 7. DWI can be charged in a farm field. It doesn't have to be public. Refusal is public or quasi-public. What about a condo parking garage, a high-rise? In State versus Bertrand, the court held a condo parking garage is quasi-public for a refusal violation. 8. If someone has a DWI and they had a prior refusal, does that count to make the person an enhanced offender under the DWI statute? It depends which appellate division case the court follows. State versus DeSoma from many years ago, a prior refusal didn't count. The appellate division this year in State versus Chun, the appellate division said a prior refusal does count if the person as a prior offense. Certification has been granted, and the state bar in an amicus is opposing this single-entity leading ruling. 9. Let's say someone has a first offense, refusal, and DWI. Can the refusal merge into the DWI so the person only gets a 3-month loss of license? Answer: no. State versus Eckett. 10. Is there an automobile exception to the search where police can search a car? Answer: no. State versus Beneflores. A car search requires exigent circumstances, and the Supreme Court also approved a mechanism for telephonic search warrants. 11. Discovery. Is discovery permitted in a speeding case? Yes. State versus Green. The court held that a motorist who has been charged with speeding is entitled to discovery respecting 1. The speed measuring device's make, model, description. 2. the history of the officer's training on that speed measuring device, where he was trained and who trained him. 3. The training manuals for the speed measuring device and its operating manuals. 4. The state's training manuals and operating manuals for the speed measuring device. 5. The officer's logbook of tickets written on the day of defendant's alleged violation. 6. The repair history for the speed measuring device used to determine the defendant's speed for the past 12 months. And 7. Any engineering and speed studies used to set the speed limit in the section of highway where the defendant's speed was measured. The appellate division also held that the stalker lidar speed measuring device had not been proven to be scientifically reliable, and as such the results of its operation should not have been admitted during the municipal court proceedings or considered by the law division. The court then remanded it to the law division for a plenary hearing on the stalker lidar, which is a type of speed measuring device. 12. Okay. Can police search the car passenger compartment for weapons if the occupant is already arrested? U.S. Supreme Court, no. Arizona versus Gant. 13. Does a school principal need probable cause to search a vehicle on school grounds? No. A school administrator need only satisfy the lesser reasonable ground standard rather than the probable cause standard to search a student's vehicle parked in school property. 14. Let's say there's an error by a police dispatcher and there's an invalid arrest warrant and someone's arrested and there's drugs found. Does that require suppression? Appellate division, yes. State versus Handy. The error by the police dispatcher in the invalid warrant requires suppression of all the evidence seized. 15. Can passengers be ordered out if there's a belief of danger by the police? Yes. The New Jersey Supreme Court, State versus May. Here the officers presented sufficient facts in the totality of the circumstances that would create in a police officer a heightened awareness of danger that would warrant an objectively reasonable officer in securing the scene in a more effective manner by ordering the passengers to exit the car. Those same circumstances authorize a police officer to open a vehicle door as part of ordering the passenger to exit. 16. Is there a plain smell document where police can search simply because of smell? Well, according to the appellate division, State versus Palmer, no. There's no warrantless search of the truck sleeper compartment based upon the smell of pot. 17. Can police search a home without a warrant? No. State versus Jefferson. 18. Can the judge suspend a driver's license for a traffic offense where the statute does not specifically say suspension? Yes. New Jersey Supreme Court, State versus Moran. 19. Can a defendant request that their guilty plea be vacated if they were not advised of deportation and now are facing deportation? Yes. U.S. Supreme Court, Padilla versus Kentucky. 20. What are the factors required to withdraw a guilty plea? Well, in State versus Slater, the judges are to consider and balance 4 factors in evaluating motions to withdraw a guilty plea. 1. Whether the defendant has asserted a colorable claim of innocence. 2. The nature and strength of the defendant's reasons for withdrawal. 3. The existence of a plea bargain. And 4. Whether withdrawal could result in an unfair prejudice to the state or unfair advantage to the accused. 21. On an unsafe driving ticket, are they permitted to have more than 2? Yes, if there's more than 5 years between number 2 and number 3. That's Patel versus New Jersey Motor Vehicle Commission. 22. If the police read the Miranda, do they always need to re-administer Miranda warnings before second questioning? Not always. State versus Niehammer. 23. Can Miranda violation be asserted by co-defendant? No. State versus Baum. 24. Can a defendant win a motion to suppress their statement? If they did not specifically waive the Miranda? No. Burgess versus Tompkins, the U.S. Supreme Court held Tompkins' silence during the interrogation did not invoke his right to remain silent. A suspect's right to counsel must be invoked unambiguously. Had Tompkins said that he wanted to remain silent or that he did not want to talk, he would have had revoked his right to end questioning. He didn't either. And 25 are drug lab reports admissible in criminal cases, not according to the U.S. Supreme Court if there's an objection, Melendez-Diaz versus Massachusetts. For additional information on recent cases, go to website njlaws.com, that's njlaws.com, or website benotguilty.com, that's benotguilty.com. For other information, contact the law office of Kenneth Vercammen at 732-572-0500. Thank you and good luck.